Our next conversation is going to be on understanding the law, but at the same time on holding the judiciary accountable. And let's start with the context for that. We've just talked about the case of Julia Wangoi, who died in custody in Nanyuki, sparking protests. And looking back at what happened, on Sabasaba Day, the family says she was walking home in the evening. She was rounded up with other protesters who were being arrested on the day. She was taken to the Nanyuki police station, where she spent the night. Following day, she was arraigned at the Nanyuki law courts, and she was released on a 50,000 shillings bond, and the family was unable to raise this bond. So by the end of the day, she had not raised it. Now she was placed under custody of the courts through the prison remand. So she was taken to the Nanyuki GK prison remand. It was during this time that she ended up dead. And the family says she was brutally assaulted by officers here. We've just heard from the grandmother speaking, and the pathology saying it's still inconclusive on the cause of death. We can see bleeding in the brain and other parts, but we still can't say that this is conclusively what led to the death. Now the questions have now gone onto social media. So she was arrested, spent the night in police custody. Okay. So she was taken to court the following day. All right. And then the judicial officer told her pay 50,000 shillings bond to secure freedom as the case progresses. 50,000 shillings. She was unable to raise it. So she ended up in remand prison. She dies. This judiciary has questions to answer. And that's why the judiciary spokesperson is here to answer those questions. The Honorable Ndemo. Good morning.
Good morning.
How are you?
I'm very well.
Under the circumstances.
Thank you for having me here.
It's good to have you here.
Thank you. Thank you. It's a pleasure to be here today.
Yeah, you're going to actually be responding to this and educating us to understand bail, bond, to understand, charges when someone is taken to court, what the judicial officer consider, and so on and so forth. But first, Janet is going to welcome you with the day's quote.
Yes. On this day, 163 years ago.
I wasn't born then.
I think those known to us were not born. Right. Ida B. Wells, who was an American investigative journalist, and she was also an early leader in the civil rights movement. She said, she didn't say it when she was born, she said it much later in 1887. She said, a man's character is his capital.
Yeah.
A man's character is his capital. What do you make of that?
Brilliant statement. You see, your character is really what determines how far you get in life. Charisma can get you into the room, but it is character, really, that will keep you there. So I think that's an astounding statement. Very true. Yeah.
I like that. Charisma can get you in the room.
Character is what will keep you there. Because charisma will wear off.
Yeah.
Does charisma know this?
Does he?
Does Riz?
He's just making.
Does he know that he can get you to the room?
Yeah, does Riz know this?
He knows that.
Very well.
He does, huh?
He does.
Let's start the conversation with bond and bail. Just explain it, layman's term. What is bond? What is bail?
All right. Thank you. So, in the court process, the most important thing that happens when you have an accused person brought before court is, rather one of the most important, is their attendance in court. If this person does not attend court, then you don't have the process going. So the purpose of bail and bond is to actually secure their attendance in court. So what is bail? Bail is, just generally speaking, it's an agreement between the accused person and the court that this accused person will attend court when they are required to attend court. And should they fail to attend court, then a particular sum of money that has been given by the court or some form of security, for example, a logbook, a title deed, will be forfeited should they fail to come to court. So that really is what bail is. Primary purpose, to get in court. Bond, very close, but then bond is an undertaking. It is not, you don't pay it upfront, but it's an undertaking that you will also attend court when required to, but should you fail, then what the undertaking that you then give will then be surrendered to the state. You will be required to pay a certain amount of money, and that will be forfeited to the state. So when you have bail or bond, you would have what we call a surety. In some instances, you have someone who will stand in for you, so they can also guarantee your attendance. And so it's important just to distinguish that side. So, but primarily, what bail and bond is supposed to do, I think is good for Kenyans to understand, that is really just to secure your attendance. And so, depending on how the court views the accused person, the evidence that is brought before the court for purposes of the bail or bond, then the court will say, fine, we are going to release you on bail or bond, or we are going to deny you bail or bond. Yes. But again, let me say this, it is a right. We start from there. Under the Constitution, it is actually a right. So it starts off very clearly that an accused person has a right to bail or bond given on reasonable conditions. They have to be reasonable. But if the prosecution feels that this person is should not be released, then the prosecution must give what we call compelling reasons. And the court must be convinced that indeed these are compelling reasons to deny this person bail or bond, because it is a right that has been given in the Constitution.
So when is bond issued, bail issued? Is it can it be one case, somebody, it's imposed both of them on the same person? Like, how does it work?
Yeah, so the court will say, we are going to issue, for example, we are going to give you a bail. Sometimes it's used somewhat interchangeably, but the court will say, we are going to give you a bail of 200,000 shillings, and we are going to have a surety, you know, of a similar amount. So you have someone else, there is your own 200,000, but you'll have someone else who is going to then be bound. So that will be like a bond. So this person will be bound to pay 200,000 should you not appear in court. So they can be used. They can be used together. Yeah.
And where do titles come in? Title deed, logbook.
So that is it's a security that is given in bail. So you will be told you are going to pay this amount of money, or you can deposit these particular documents. Of course, they must be verified to confirm their authenticity and also the value, so that the value is equivalent or higher than what the court has given. So, I mean, the court can say you're going to be given a bail of a bond of, let's say, 5 million. So there needs to be then a verification of the, first of all, the document itself and the value, so that it is comparable with what has been given by the court.
Yes. Is there a legal threshold for denying bond? And then do judicial officers strictly adhere to it?
So the court will look at various factors when considering whether to give you bail or bond. And some of the factors the court will look at is, for instance, if you are a flight risk. Remember what we said is the most foundational thing is that you appear in court. So if, for instance, the court does not see that you are going to be a flight risk at all, that you will attend court, you can actually be released on what we call your personal bond, which means you pay nothing. You just give an undertaking, I will come to court, you know, because we know you are found on this show, Eric. If anything happens, you will be here. So God forbid you'll be charged for anything. But then it's taken that it's easy for you to come to court. We know where to get you. You are not about to leave your employment, you know, so it will be easy for you to come. So the court can actually give you bail, a bond, without you having to pay anything. But then there are other factors now the court will look at and say, okay, this person is a flight risk. For example, they are foreigners. They have no fixed abode. This offense, another factor the court could look at is this person may interfere with the investigations of the case if they are still ongoing. The court may also look at this person may be a threat to either witnesses or the victims of the offense. And so the court will consider all that, among other factors, and say, considering these particular factors, then we are not going to release this person on bond. But remember that this is a right. So the court really needs to be convinced. The court needs to be convinced that they are compelling reasons. So those issues that I have just mentioned need to be brought forward to the court so that the court can then see. So because the court on its own motion will just, this person has been charged, okay, we'll give them the bail or bond on the terms that the court thinks are reasonable. But if the prosecutor thinks otherwise, then you need to state that this person is a risk, is a threat to the society. They are likely to interfere with the investigations and such are the reasons. Then the court will, if it's convinced, will then deny bond.
Okay. At the moment when you are being brought to court, before you face the charges, you're brought by the prosecutor and the police.
Yes.
Right? And then the court will give you the bail and bond terms. By when should you pay so that you can go home? Or are you allowed to go home as you look for this money to come and pay to the court? Can you tell the police, sasa? Sirudi huko kwenu.
If you do that, it will defeat the purpose. Because if for instance, what you're charged with is very serious, what is at stake is serious, and the court says you need to pay this to be released, and someone says, let me go, then I'll come back, they may not come back, you see. So it has to be paid before the person is released. Okay. So that is why you would have maybe a close relative with you or your lawyer together with you, so that once the court pronounces itself and says, these are the conditions that we are attaching to the bail, then those conditions are met right there. They are processed. Once they've been processed, and then you are released to go, and then come back the next time the court has said you come.
So if you've not come to court with a relative, with a friend, people are not aware that you've been arrested, you've been taken to court, you basically have to find a way of reaching out to people while you are in police custody for them to start securing for you the bond on your behalf.
Certainly. Yeah, because someone has to know. Someone has to know. Well, sometimes you may actually have, for example, the funds on your phone. So you could process it right there if you do that. But if then you don't have, then you would require to have some intermediary, communicate with the family or advocate to be able to have that processed for you to be released.
When am I handed over from the police to the prisons?
So once from the police
to the prisons.
So
I was brought to court.
You're brought to court exactly. So if the police bring you to court, you are charged in court, or your matter is brought before court, because sometimes you're brought and then it is even before the charging that you apply for the bail. So once the police brings you to the court and the court has handled your matter, after that, you don't go to the police. You are then handed over now to the prisons. They take over from there.
This is before you've been convicted of anything?
This is before even the trial starts.
Even the trial starts.
Yeah.
Okay, maybe we'll revisit that.
Okay.
Let me begin with a question on how much, I know it's bail and bond vary from crime to crime.
Yes.
But do they take into consideration someone's economic ability at any point?
The court looks at a number of factors. That may be one of the factors, but the court will also look at, for instance, the seriousness of the offense that you've been charged with. And of course, it is an issue that requires a lot of discretion because you have to really balance a lot of things. And no two individuals are the same. No two circumstances are the same. We could all be charged with the same offense, but our circumstances are different. You know, maybe one was you've been a convicted fellow before, so now when we are looking at this, it's a little different. But the court has to weigh all factors looked at different. So in some instances, I mean, like the unfortunate current case we have, there are those who are saying that amount was too high. There are some I've heard who are actually saying it was too low, considering what happened, you see. So a judicial officer, yes, a judicial officer now has to sit and determine, considering the circumstances of this case, considering, for example, what may have been destroyed, considering the likelihood of this person coming to court, what is reasonable? Right. What is reasonable? And you see, reasonable has been left to the discretion of a judicial officer. But let me hasten to add that we have guidelines on bail and bond that guide judicial officers. But it is a discretionary power that they have, because everyone that comes there must be looked at as an individual. So the court will look at various factors, and you can't second guess what the court will say for this particular one. You know, I will give this bail. For this one, I will give this bail. They must look at what are the circumstances that they have. And that is why you cannot also standardize. Right. You can't say every offense of, stealing is going to be 100,000. Yeah. A case of defilement will be 100. No, you can't do that. You just provide guidance, case by case, so that they have the ability to listening to the facts. When they are presented before court, we'll say, okay, this one, I think we'll do this to cause them to come to court.
In the case of Julia Wangoi, what had she been charged with? Or what was in the occurrence book?
So there are a number of, because they were charged, it was a large group that was charged, and the charges were malicious damage to property. That was the charge that was laid against them.
What is the bond range for that charge?
So that's exactly what I was saying. There is really no bond range, because if you come and you destroy a mast for radio station, for example, put it down, that's some serious millions. What you will then be, the bail terms are likely to be more serious. But again, the court must warn itself, because one of the important principles in bail and bond is that first, someone is presumed to be innocent until proven guilty. There is also the principle that you have an obligation to attend court as an accused person, So there must be a balance between those things. So the amount will really vary. It will look at the property, the seriousness of the offense, look at the person. So if for example, it's a child, let's take that. If it's a child, then you may say, a child, they are unlikely to abscond court, so we'll have the child released maybe on the undertaking of the parent. So there may not be some amount of money that is put in respect of that particular case.
So the judicial officer also is expected to be aware of the circumstances. Right? Prevailing circumstances in a particular region, in a case, and so on and so forth. We're going into a break, but my question after the break would be, so a judicial officer who is sitting in Nanyuki knows that there were demonstrations in Nanyuki yesterday, and knows that there were people who were arrested yesterday, and knows that those people are going to be brought to my court this morning. And many of them are youthful people. And by morning, the judicial officer must be knowing that there was some property that was destroyed yesterday. So, Honorable Ndemo, how do you handle such a case? But let's take a break. You know, I'm not telling you to second guess that particular judicial officer, but in this particular case, I mean, what is it that would be going through a magistrate's mind when they say, all right, I release you on these bond and bail terms? We're taking a break. The Judiciary spokesperson, he's also, no, let's start with the Deputy Chief Registrar of the Judiciary. He's also the Judiciary spokesperson. The Honorable Paul Ndemo is our guest this morning. We're talking about bail and bond terms, when they're too tight, when they're loose, when people walk scot-free. Back in a moment.
Do that.
We come back to our conversation in a bit, just sampling some feedback. Emmanuel Templar says, Judiciary has done a lot to protect freedoms, despite deliberate efforts by government to erode the same. Then he goes on to say, government kidnapped CJ, tossed him out of the country, despite extradition laws. Okay.
This government did what? The CJ?
Yeah.
Hey?
It's
No.
Emmanuel Templar.
Okay.
Anyway.
Hey, which one? Government of where?
Bessie
Bessie J.
Sorry.
Oh, Bessie J.
Okay, now we're in a different country.
I
Okay.
had the CJ.
I had the CJ as well, right? Okay.
All right.
This is just speaking to what we covered in the last hour, the burial of Bridget Njoki. Anon 11 says, the sun doesn't rise for a nation that buries its children in silence. The sun doesn't rise for a nation that buries its children in silence. What you're seeing with that 12-year-old is part of a broader, deeply troubling pattern, but we're not stopping until justice is real for the people. Aya.
Very well
That's
said.
very
Profound.
well said.
Profound.
Eric, you had asked.
The Honorable Paul Ndemo, a judiciary spokesperson. Now, magistrates have been in this country since June last year. Even when the people were being arrested and being taken to court, they were finding magistrates and they were releasing them. In fact, we saw very many cases where they would just say, just release them. Looking at the charges, what you're presenting here doesn't hold water. Release as much as possible.
Yeah.
Or even coming up with lenient bond and bail terms. Now, when a similar thing happens again a year later, there are protests and demonstrations and young people are presented before court. And they're brought before you. Let's just put you in a magistrate's bench. They're brought before you. And you're seeing it's young people, it's as a result of yesterday's protests. And yes, there was torching of tires, there was arson in some instances, and people have been brought before me. What would you consider when setting the bail and bond terms?
All right, thank you for that question, Eric. So you need to look at, let me put myself in the shoes. I need to look at what are the prevailing circumstances. And this is why we talked about look at what is happening. Every judicial officer will look at what are the circumstances before me. The way I handled a case 2 years ago is probably not the same way I'll handle the case today in terms of bail and bond. In terms of the law, it is fixed because a case must be determined by facts, by evidence, and by the law. That is very clear. But in issuing of bail and bond, I must look at what are the prevailing circumstances. What is it that is happening? So someone who comes today and there is really no threat of them not coming to court, no big deal. But if then something happens that makes the premium very high for the person to come back to court, then I must look at it as a judicial officer and determine that I must put reasonable conditions, yes, but a little more stringent to ensure that this person comes to court. So it is not fixed. It is not standard. You have to be aware of the prevailing circumstances. But again, very underlying point, they need to be reasonable because it is a right.
Okay.
Yes.
The Court of Public Opinion has listened to the case and they have determined that the judiciary was unfair in the case of Julia Wangui. That this lady is brought before court and she's slapped with a bail and bond term for 50,000 shillings. And that's how she ended up in remand prison and was not able to even pay on that day. As a spokesperson for the judiciary, how do you respond to the court of public opinion?
So first, we obviously are really saddened by the death, and we condole with the family because it's a really sad situation. Nobody who is brought to the court or nobody who is subjected to the justice system should actually suffer harm or death. That is why we have a justice system. That is why we have a constitution. If someone has been found to have offended the law, there are very clear processes as to why, as to how they should be brought to court and what should happen. And in the justice system, everybody has a responsibility. And the court plays the role of being the last bastion for the defense of rights. So by the time someone is being brought there, it is for the realization or for the implementation of those rights. So we really empathize and condole with the family. It is a very sad situation. It should never have happened in that manner. That said, sitting where I do now, and having said what I said about looking at the circumstances, it would really be very speculative for me to sit and say that bail was too high or it was too low. And as I said here, there are some who are saying it was low. There are some who are saying it is too high. So it's really dependent on the circumstances that the judicial officer looked at. What was it that was on the ground? What were the charges? What were the other considerations about the case proceeding, and many other factors, which I sincerely cannot really speculate. But we are very, we are very saddened as a judiciary, because it should not be that someone who has been brought, whether in conflict with the law or someone coming to seek their rights in court, ends up dead. It should not be that.
There's a question here on the fact that it seems like there's been disproportionately high bond terms for protest-related arrests, even non-violent ones, even for first-time protesters who've been arrested. That seems to be a trend. I want to say anecdotally. I may not have some of it, but we saw that a lot. It's your first-time offender, maybe it's non-violent, and then it's a disproportionately high bond term. So it speaks a little bit to whether it's equitable. And I think that's a concern that a lot of people have.
Right, up to 100,000 shillings actually from 2024 protests. And the charges are non-violent often. So then again, yeah, we don't claim to know the law, but there does seem to be some disproportionate bail and bond terms. And again, it is the same judiciary that has, by and large, been lenient in cases of protesters as well. So many have been let go on personal bond or without charge, or cases dismissed, because we assume that the judiciary can see that there's a weaponization of the law happening, or an attempt at least, and then that stops, at least the court. But on the other end, there's still some people who are getting very stringent bond and bail terms, and in the case of Julia now. So then, as you answer that also, how do we protect young people who are exercising their right to protest from unfortunately having the law weaponized against them, because they could find themselves charged with something that does not hold water, or something that they were not a part of, that does have high bail and bond terms, and then they are unable to raise it, they end up in prison, and we see what the cycle, how that happens. But yeah, maybe start with Janet's question.
I'll go back to the circumstances of the case, really. To sit and determine what will be reasonable in case A and what will be reasonable in case B and case C and D, and say that this should be standardized is really an impossible task, because what I said is we have provided guidelines. At best, we have a policy which says this is a bail and bond policy. These are the factors you look at. This is what you consider. But you cannot then say that this is what you will do, because sitting on the ground, and Eric did ask before the break that you live in this particular community, so you have an understanding of what happens. That is true to a very large extent. But the other side of the work of the judiciary is you are a referee. And I remember I said that when I came here again last time. The judiciary is a referee. The referee will not get into the match and say, this team I know is stronger than this team. And so already I will be looking out for the striker. When I see the striker about to strike and hit the ball, then I will be like, I think it's a goal. I'll blow the whistle even before the ball gets to the goal. The referee may actually have an idea that this is it. But then the referee will have to wait and see how is the game being played. That is the position that the judiciary holds. You are a referee for two teams. You have to wait and see how is this played. This is brought before you. The judiciary never calls to itself cases. It waits for disputes to be brought before it. It waits for accused persons to be brought before it. Whether it is terrorism cases, whether it is, protest-related cases, somebody else is the one who brings those cases. The judicial system that we have in Kenya is what is called the adversarial system, meaning there are two parties. There's an adversary, here and this other side. So you have to wait for these two to bring it. There are some judicial systems in the world where the court, on its own motion, in fact, even some here in Africa, on its own motion, can actually call even for evidence and say, can we go and investigate and bring that so that we can satisfy ourselves? That is not the system we have. So the court here will sit, wait, you bring DPP, you want to charge these people with the offense that you have determined to charge them based on the investigations you have received, that is brought to the court. Then you, prosecutor, must convince the court beyond reasonable doubt that this offense has occurred. Then the court makes a decision. So sometimes I think we put some blame on the judiciary, whereas the judiciary really is an independent referee waiting to determine which player here has proved their point. But the referee does not get into the game. You wait for what is happening and then you make the determination.
Your Honor, in instances where this referee is actually seeming to perpetuate an injustice, that person who is going through the system will not see this referee as impartial in any way.
Yes.
Let's just say that Julia did not die in police custody, okay? But Julia and other people end up spending days in remand because they're unable to raise 50,000 shillings of bond, or others 100,000 shillings, or somebody else 10,000 shillings.
Yes.
And then this person, with a magistrate not having considered what are the circumstances, right? Like it's a whole group of people that are brought, and the prosecution speaks, and the magistrate says, all right, so I release them on these bond terms. Because this is what happens in court. They don't interrogate each person. So wewe, unaitwa nani? Ulishikwa wapi? Unaishi wapi? Unafanya kazi gani? Those questions don't happen at that point. At that point, it's only later. So imagine that somebody has a young child. This is somebody who does not have a job. This is somebody whose family will not be able to raise this bond, and they've been sent with everybody else to remand prison. Do you see a perpetuation of an injustice on such a person by the judiciary?
Very good question. What happens is that there is a mechanism where you can have, if you feel those terms are too stringent for you as an accused person, then you can actually seek for the review of those terms. You can say, Your Honor, you gave this particular bail bond conditions, but I am unable. And I am seeking for a review, to lower these conditions so that I can be released.
Immediately?
Well, a few days later, one can actually do that.
But
so that then
a few days in remand.
Yeah, well, so the system is you have gone to court, you have been charged. The application has been, the court has actually given you bail, and then you were like, okay, this is too high. You then can just come back and do that. And in fact, in some instances, what we have done in order to promote justice, is to go to the prisons themselves and find out, why are you in custody, in remand now, waiting for your case to proceed? And some people say, I was charged and I was given bail of 5,000, 10,000, and I've been here for 2 months. And in some of those cases, we've actually now, on our own motion, asked the courts to just reduce further, so that now people can actually just go. So the court can also do it on its own motion.
Very good. My question is...
But the point is that it is available.
Is there an injustice? That's my question. At this particular point, where the magistrate has not asked me my circumstances, the magistrate has simply said 50,000 shillings, right? And he said they've got to consider it as to be reasonable, and so on and so forth. For it to be reasonable, for you to judge that this is reasonable, you have got to ask me a question.
Reason with me.
You have to reason. You have to ask me my circumstances. Where do you live? What do you do? Right? All those things. You work at Nation Media Group, all right? You report on a daily basis, okay? And so on and so forth. Then you can tell this is a circumstance with which I shall impose this bail and bond.
Right.
When that question is not asked, is that not an injustice?
No, in some instances, the court would ask that question.
In these cases, when they don't?
Well, then you have the opportunity to bring it up.
Is it an injustice?
I wouldn't say it's an injustice.
What is it?
It is the way the system has worked over the years.
Is it a just system?
But we started with you explaining
Yes.
that everyone has a right to bail or bond.
Yes.
If it is denied, there are circumstances, and that the bail must be reasonable.
Exactly.
So then reasonable can only be ascertained after you know the circumstances of someone. Reasonable is not just reasonable to the court, it is reasonable to...
Obviously, yes.
Yes, to the defendant in this case. So then how can we say that it is reasonable if those questions have not been asked?
So you see, the idea is it should be reasonable, yes, to both sides, to ensure attendance to the court. So if the court feels that then this is not working out, and actually, even at that point, really, at that point, nothing really stops the accused person from just saying that, you know, this is, could I say something to court? And you've probably seen this if you've attended any court where you find an accused person just raising their hand and the magistrate asks, hey, what is it? So you can raise it at that point. Nothing really stops you. But the way it has been traditionally is you are given the terms, then you process them. It is taken that it is well. But if you find then there's a challenge, nothing stops you from raising it to the court, so that then it is reasonable.
Yeah, I may not be
but
able
remember,
to raise it if I don't understand.
But remember, and that's why we are here.
If I don't have knowledge of the law, if I don't have counsel,
I know
if
that.
I don't have counsel, if I'm being arraigned with 10, 20, 30 other people.
I know that. And that's why we are really going out of our way to try and just create some civic education around the court processes, so that people can understand this is what it means when this happens. This is the party that is responsible. You know, you have the police investigate, the DPP, they prosecute. This is what we do in this particular case, and we are engaging in all platforms. We are very active on our X. You know, just communicating. This is my second appearance here. We are on other media. We are just trying to educate and say this is what it is, because there's a gap.
Yeah,
Admittedly,
engaging is
there's
one
a gap.
thing, but do you admit that there's some reforms that are needed? Because maybe there's something here to reflect on. We need to rethink how we are calling out for bail and bond. I think somebody needs to champion reforms from within, because it's now coming to light that there doesn't seem to be equity.
Right. And that thread that Eric put, being cognizant of the circumstances and the times we're in, and a lot of the ways in which people are arrested and they find their way to court. That's already a miscarriage of justice, because often it's unarmed, peaceful protesters who find their way, or people who are picked up on their way home, and it's just, oh, you're bundled in with the protesters. Then you find yourself being asked for 50,000 shillings. So again, it's a miscarriage of justice from the arrest and then now to the bail and bond terms.
So you see that, I mean, it's a good point you raised there. The only challenge is that the person you're sitting in this studio, for instance, now. If something happens, on Moi Avenue, you really cannot be expected to have first-hand experience about what happened. You are sitting here, the story you will be told is by a third party. They will tell you, this is what happened, this is what happened. You are not there to see it.
Yeah.
So sitting as a judicial officer, when you are told, you know there are protests, yes, that have been going on, and all, but you don't, you will only know the circumstances when they are presented before you. So it would be premature. Remember, we must balance. We really must balance the rights of the accused persons and also public interest. That has really to be balanced. That is a big thing. But I do not deny, Janet, that we can have, and there's always room for improvement, discussion on how can the law be more facilitative? How can the processes that are there make it that much easier? And one of the immediate, quick, low-hanging fruits is civic education, because I think there's so much that people don't know or that sounds so mysterious that if someone just knew, then it becomes so much easier. I mean, how many people know, for example, that when you go, if a police arrests you, you can actually get bail at the police station. You can get bail at the police station and you pay a bit of money and then you will appear in court and that money will be returned to you. How many of us know that? It's in the law, it's in the books. So there's a lot of laws that we have, but there's a very big gap in terms of civic education. And we are going all out as the judiciary to educate, to sensitize, because we are here for the people.
And we'll hold you to that. We're running out of time, but I didn't want to let you go before we figure out what is the legal threshold for terrorism in Kenya. We saw that about 1,500 people have been arrested countrywide, with 71 facing charges of terrorism after June 25th and July 7th protests.
Okay, first, terrorism is a very serious offense. And that is why in our legal framework or our legal architecture, there is a whole statute that talks about terrorism. It's called the Prevention of Terrorism Act, specifically. Unlike other offenses, you have them in the penal code. You have very many offenses in the penal code. But this one, because of its gravity, the serious nature, there is a whole law that talks about it. So there are very many offenses that have been put there. Now, just like any other criminal offense, the threshold is the same. It has to be proved beyond reasonable doubt. But now, again, because of the seriousness of the offense, so without vacating the liberties that somebody who has been charged has, because they still have rights. They still have a right to bail and bond. They still have a right to be presumed innocent until proven guilty. But because of the nature of the offense, there is some special considerations there. For example, someone can be held for up to 30 days. You go to court. Of course, the first 24 hours, they have to be brought before the court. And you can go before the court and say, we are holding this person on terrorism charges. We are still investigating one or two. We are asking that court gives us time, and the court will give you up to 30 days the first time. And you can come back again and ask for an extension of that time. That is not, for other offenses, you will have to work very hard. For you to show that we need to extend time, the court will ask you, what were you doing? This is a simple offense of, stealing 1, 2, 3. You should have finished that before. But because terrorism is its very nature, the complexity, sometimes, spread across jurisdictions, across different countries, you find that there's that limit given. But it still has to be proved beyond reasonable doubt.
We have a minute.
Even for the 30-day holding at that point. Because what I'm foreseeing here is the weaponization of terrorism charges against people who, are protesting.
So in that case, again now, the prosecutor must give the court what is called compelling reasons. The court must be convinced, why do you want us to keep this person for an extra 30 days? It wouldn't be given automatically. I said 30 days, but it's not automatic. The prosecutor must still be able to prove and give compelling reasons why this person should be held longer. Otherwise, the court will be like, there is no reason to hold this person. We are going to give them bail. If you think there are flight risk, we'll confiscate their passport, for example, or we will say they need to be reporting to the police station every 2-3 days in a week, because what is most important is for this person to come here and that they are not a threat to other people outside.
Oh my, we are completely out of time. I wanted you to do a quick fire in 60 seconds. Kikombe asking, what's the reason that justice takes weekend breaks for petty offenses? Unashikwa loitering kwa niambaya, and you have to be locked, endangering your life in cells until Monday. Bakari Sagna, to reduce reliance on cash bail, which disproportionately punishes poor people, can mobile phone tracking or electric monitoring be applied by police now that DCI are using it to track suspects? Just a few questions. We are completely out of time. I don't know if you can speak to any of those in 30 seconds.
Yeah, the first one was on the issue
over the weekend.
The issue over the weekend.
Justice take a break over the weekend?
No, it's something we're thinking about. It's something we're thinking about and seeing, can we have courts, you know, maybe overnight courts and the other. It's something that is in the works. But the issue of capacity is a big deal because we are seriously overstretched. Some of these things are resource-based. If we have the resources, we can consider that. But it's something we've actually been thinking about, having even a night court, you know. But of course, it will require some resources to build on that.
We're
Yeah.
out of
Tracking.
time.
He's saying electronic tracking as opposed to cash bail, which disproportionately affects poor people. Yes, electronic tracking. So
yeah, I mean, it's brilliant idea again, but your guess is as good as mine. I think we must, as a country, be willing to invest in the justice sector. If we say that this is done, then, I mean, it can be done.
All right.
It can be done.
The Honorable Paul Ndemo is the Deputy Chief Registrar of the Judiciary and the Judiciary Spokesperson. He's been our guest this morning, talking about bail and bond terms. We'll have to invite him again here to basically look at that and look at the National Council on Administration of Justice, where all of you sit together, and the job that you're doing. Keep it here for more conversations. In the next hour, we talk about UN Women. It's coming up to 8 a.m.